This lecture provides an introduction to the doctrine of private nuisance. Most current property law books classify nuisance within the category of a land use control. This means that the law controls how a property owner can and cannot use their land. It could be analogized to a zoning ordinance, although the two are quite different. With a zoning ordinance, the zoning body, such as a local municipality, essentially tells an owner what they can and can't do, typically in express terms. Private nuisance is much more open-ended and typically asks a question about reasonableness. Is one landowner's use of their land reasonable in light of the harm that this use causes to another landowner? And while zoning ordinances are typically enforced by the local government, nuisance, that is private nuisance, is enforced in court where one neighbor sues another. Another area of land use control that's also similar is the law of covenants. With a covenant, neighbors come together and agree upon a set of requirements, rules, and obligations associated with how they can and can't use their land. For instance, my neighbor has, in a covenant, promised not to cut down their trees that are in their backyard for a period of 99 years. An obvious difference with covenants is that they are thought out and agreed upon beforehand, whereas nuisance depends upon reasonableness, and that reasonableness tends to be judged after the fact. Thus, the difference between covenants and nuisance really falls along the same lines as the difference between contract and tort. In the next class, we'll delve into the elements of private nuisance. For now, thanks so much for listening to Property Law Online.